All right, everybody, let's get this show on the road. It's time to talk about a very popular subject and always in vogue when it comes to legal issues in sport or sport in the law, and that is negligence. So, we are going to be talking about an area of the law that often interacts with sport, recreation, and related fields. Now, before we talk about negligence, we should probably go back and define what the name of the family that negligence is in, which is called torts, really is. So, a tort, which negligence is a type of tort, is a wrongful act, or also known as a civil wrong. And it is committed against one person to another. So one person commits a tort against another person, and the law imposes a penalty on whoever committed the tort as a result. And there are different types of torts out there. There's intentional torts like assault or battery, which I'm sure you've heard of. And then there's negligence, which is a class of tort. So understanding the nature of torts is very important. Now, the fundamental questions here are such. What is the purpose or purposes served when imposing liability onto a party? And the one other fundamental question is, to what extent should liability rest on fault? And we're also asking, what was the state of mind of the actor? Did they do this intentionally or was it unintentional? So, a big distinction to make between contracts, which is a very popular type of legal issue that often interacts with sport and recreation, as well as torts, is that contracts exist as a legal mechanism to help effectuate the intent of two parties. They got together, they negotiated the terms of the contract, and then the law steps in to actually help impose those terms so long as there's offer, acceptance, consideration, legality, and capacity. Now, torts is a little bit different because with torts, the law steps in not to enforce whatever the parties had agreed to, but it doesn't judge so long as that meets the threshold requirements to be a contract. But here, the law of torts says one party was injured by another party's wrongful conduct. And as good public policy, the law is going to step in and punish the offending party that committed the tort and give the party who was aggrieved some sort of financial compensation to try to make them whole. So the law of torts really exists to make people whole again, to compensate someone who was hurt and punish the party that committed the tort. So, okay, now that we've got that taken care of, what is negligence? Well, negligence is conduct that falls below a standard of care that results in some sort of either unreasonable or foreseeable risk of harm. And the popular types of how someone commits negligence is that someone fails to act as a reasonable and prudent person under the circumstances, or someone did not, or someone, I'm sorry, someone that that a person would do or refrain from doing that is not that they would not be expected to do under the circumstances. So again, potential examples are someone fails to act as a reasonable and prudent person. They are supposed to do something and refrain from doing something, or they did something that a reasonable, prudent person or a reasonable person should not be doing, such as driving under the influence. We would expect that a reasonable and prudent person would not be driving under the influence. And so the elements of negligence are duty, breach, damages, and proximate causation. The duty of care is established, and we'll talk about how that occurs. That individual breaches the duty of care that's been established, and that breach of the duty of care results in some sort of injury, and that injury would not have occurred but for the breach of the duty of care. So let's take an example of this to help illustrate the concept. I imagine that many of you have either heard of Mike Rice or heard of the scandal involving Mike Rice, but we'll take a couple of minutes and we'll come back and we'll talk about this just ever so shortly. But this is a great way to illustrate from a 1,000-foot or 10,000-foot viewpoint the concept of negligence.
Rutgers head basketball coach Mike Rice's fiery style has been on public display before. Get tossed out. Known for his coaching intensity, Rice was suspended by Rutgers for 3 games last December for his behavior at team practices, with few specific reasons cited by school officials at the time as to why. This is why. This is just some of the video that led to Rice's suspension. Outside the Lines has obtained not only the roughly 30-minute video reviewed by Rutgers officials, but also hundreds of hours of additional footage of Rutgers practices from the 2 seasons prior to this year. There are shots of Rice heaving balls at players, even at their heads, which you can see better here when the tape is slowed down.
Had you ever seen a coach do that?
Never. I mean, unbelievable to me that somebody would feel that that technique can be successful.
Eric Murdoch was a first-round draft pick and played 9 seasons in the NBA. He was hired by Rice, whom he'd never met, in June 2010 to be Rutgers Director of Player Development. Murdoch says he went to Rutgers Athletic Director Tim Pernetti as early as last summer to inform him of Rice's coaching tactics.
I mean, the problem is that, whenever Tim Pernetti came into the gym, Mike Rice was on his best behavior. He's clapping, he's positive, As soon as Tim Pernetti leaves, every kid is an asshole, bitch, and that's how it was. To witness that video and to see your coach physically putting his hands on players, physically kicking players, firing balls at players from point-blank range, the verbal abuse, the belittling. I was in total shock that this guy wasn't fired immediately on the spot.
Okay. So that's the video. So if we just, again, from a 10,000-foot view, knowing very little about negligence, other at this point than that it's conduct that falls below a standard of care that's set by society, and that the law will enforce some sort of remedy, and that someone has a duty to act as a reasonably prudent person and engage in some sort of conduct, or refrain from engaging in some sort of conduct. So, from our standpoint, it seems like Mike Rice had a duty of care to not be physically abusive to his players. Don't hurl vitriolic, homophobic, just completely unacceptable language at the player. So don't throw projectiles, don't touch them, don't push them, and don't be verbally abusive. Now the question becomes, why do we think that this conduct, I'm assuming we think this conduct, is a breach of the duty of care? And again, we can go through that by looking at some of these elements here. So under duty, the duty of care is established by usually three different ways, one of 3 different ways. The plaintiff in the Mike Rice case, the players are owed a duty of care that is set out by either the relationship of the parties, a voluntary assumption of the duty by the parties, or statutory duty. In a statutory duty, if statutory sounds similar to statute, well, you would be right, because in statutory duties, the duty of care is established by some sort of law that's passed by the legislature, and then people who are affected by that law, who fall into that law, must abide by that standard of care. So the relationship of the parties, often in some sort of close relationship where one would reasonably expect that there would be some sort of duty to treat someone in a protective manner, or that there's a vulnerable population that is receiving some sort of instruction or guidance by the other parties. So the relationship of the parties, we would have step parent and child, or parent and child, or player and coach within the sports context, teacher and student. By the relationship of the parties, there's certain duties that are owed from the coach or the teacher or the parent to the person who's usually younger and vulnerable and there to receive some sort of benefit. Voluntary assumption of the party would be somewhat a situation where you're walking down the sidewalk or you're running and you see someone on the side of the road and they've gotten into a car accident, and you can choose to walk by and not help them, or you could choose to actually help them. Now, if you actually voluntarily go and try to help them, then there's a potential standard of care that you need to abide by. You can't make the situation worse. You can't do something that would further injure that person. However, as we'll see, and if you do injure that person, you could potentially be liable for negligence because your conduct fell below the baseline standard of care that the person being rescued would have expected, or that the society would have dictated you need to adhere to. You can't, try to pull them out by any means necessary and end up hurting them more, or doing something that exacerbate the situation. But as we'll see later in this lecture and in the textbook, there's certain statutes again that give immunity or protection according to the law to certain types of individuals or entities to encourage them to help or to be to respond to the situation. So this would be where a good Samaritan law might come into play, that says if you do voluntarily assist to help save someone in a car accident, or if they're drowning and they somehow die, or somehow the situation is made worse, the person that was trying to save them won't be subject to a lawsuit for their role in that because of the Good Samaritan law. And then finally, statutory duty. Again, like I said, statutes might require a specific duty of care to be owed, such as some states have laws on the books that require certain types of establishments like gyms or workout facilities to have AEDs, automatic electronic defibrillators, on hand, so that if an emergency does occur, that technology is there to help potentially save a life. So these are the different sources of duty. So once the duty is established, the requirement is that the person who falls under the duty must protect that individual from a foreseeable risk of harm. And if it was a foreseeable risk of harm, then that person or establishment must try to protect them, act reasonably under the circumstances. But if it was something that's not foreseeable, if it's unforeseeable, then no duty of care exists. So, for example, being hit by a foul ball at a baseball game is very commonplace nowadays. So baseball stadiums have a duty of care to protect people who go to the games from that foreseeable risk of harm. And baseball stadiums do that in various ways. They put up protective netting and screening in the most likely areas that balls will go into the stands. They broadcast announcements periodically through the game warning people to pay attention. They have written warnings on tickets warning people of the risk of foul balls going into the stadium. They could do a litany of other things to try to protect people from that foreseeable risk of harm. But some more modern examples of potential risks to spectators in the stands are something like a hot dog cannon. It's a high pressurized air gun that shoots hot dogs into the stands. Is that a foreseeable risk of harm that someone could be injured by the hot dog? I'll leave that to you. We've got on the right here a mascot who actually at one time, this mascot for the Tennessee Titans allegedly ran over the foot of a visiting team quarterback during halftime, and that quarterback sued the mascot as well as the Tennessee Titans, and under the law of negligence. So the question becomes, was the risk of harm of the mascot running over your foot with an ATV during halftime, is that a foreseeable risk of harm? I'd be curious for you guys to chime in to let me know whether you think that is a foreseeable risk of harm. But examples of duty of care within a sports or recreation setting is obligations to warn of foreseeable risks of harm or correctly supervise people who go to your establishment and are using your services. Supervise, instruct, qualify or hire qualified staff, which we'll talk about in negligent hiring next chapter. So once a proper standard of care is established to act with as a reasonable and prudent person under the circumstances, a breach of the duty of care would be a violation of that legal duty of care that's owed to the other party. So perhaps a violation of the duty of care may be lifeguards who are not really paying attention. They're texting while they're on duty as opposed to monitoring the pool. Or a trainer is not rendering the type of care that would be expected of that person under the circumstances. And you probably ask, well, how do we know what that standard is? Well, under the standard of care, an individual is supposed to act as a reasonably prudent person, this mythical, reasonably prudent person. And a reasonably prudent person is a fictional construction of the average person in society. And they are supposed to act as how the normal person in society would act. However, in terms of the risk, there's different types of risk, and the law of negligence responds accordingly. So if someone injures themselves due to an inherent element of the activity, there is no duty to protect. So someone pulls a muscle while playing sports. That is not something that is actionable. Now, if someone engages in ordinary negligence, meaning that, again, it's conduct that falls below a standard of care and it's unintentional, then that could violate the standard of care. Now, if something is an intentional failure to perform a duty and disregard the consequences, such as, let's say that in a facility who is hosting a gymnastics meeting has a duty of care to make sure that the facility has the necessary padding where it's supposed to have and all the necessary equipment is well maintained, and they intentionally fail to perform that duty and disregard the consequences of someone being injured due to lack of padding or lack of proper equipment, then that would be gross negligence, and that would create a higher burden for the defendant to overcome in terms of negligence. So the standard of care is at the standard as a reasonably prudent person competent for the position for which the individual holds themselves to be qualified. So historically, standards of care for people might have differed based on if they were in the country or in the city. But nowadays, it's only one standard of care. So going back to the trainer example, if a trainer is a trainer is held to the same standard of care as someone, a person who is brand new to being an athletic trainer, is held to the same standard of care as someone who has been an athletic trainer for 10 years, because it's the position that they hold themselves to be qualified for. So that creates potential problems if you're just entering the field. And again, foreseeability is about whether or not the risk was likely to happen under the circumstances. And then that person is who is bound by that standard of care must provide that the type of care that would be qualified or that would be appropriate for the person that for the position that they hold themselves out for. So, for example, high school and middle school football is something that's very hotly debated now. Should middle schools and high schools continue to offer tackle football because of the question of foreseeability? Again, people are becoming increasingly more aware of the risks that football and other contact sports pose because of the violent nature of the game, leading to things like CTE and permanent injury. Now, the question becomes, is it foreseeable that someone would become seriously injured by playing football? And foreseeability, if it's a foreseeable risk, then it is a reasonable, it is a foreseeable and reasonable risk of harm, and high schools high schools and middle schools and other schools that are offering football must take precautions to protect their students. So this is something where the question becomes, is the risk too high to actually allow this sport to continue? So once a duty of care has been established, once there's a breach of that duty of care, and once there's an injury here, then we move to the question of causation. And causation just simply is a direct and uninterrupted connection between the breach and the injury. So if there was nothing there that severed the direct relationship between the breach and the injury, then proximate cause is met. But if someone breaches their duty of care at one point and several other things happen that lead to the actual consequences of the injury, then the question of negligence is less, the question of causation is less clear, and proximate cause may not exist. And then finally, the final element here of negligence is damages. And damages just means that there's some sort of injury resulting from the breach of duty. So it could be some sort of physical, psychological, or economic injury to that person themselves or their property. So within the Mike Rice video, what was the injury? Perhaps it was psychological damage. Perhaps his antics led to a physical injury of someone. So we don't know, but these are potential damages based on that example. So different types of damages. Economic loss is just the economic cost of the negligence. Pain and suffering, that's someone's physical suffering. Emotional distress, that's mental suffering. Physical impairments, your inability to perform a function if you lose a body part or if you're unable to engage in a life activity as a result of the injury. That could be something you get compensation for. And then also different types of damage exist in addition to compensatory damages where you're trying to get money for your loss. Punitive damages is actually an additional type of money damages that you could ask the court for to punish the other side, to make an example out of them. So those are the elements: duty, breach, causation, and damages. So now we'll talk about defenses to negligence. So the first defense is if there's no actual meeting of all four elements of negligence. There's no duty, breach, causation, or damages. So if you cannot prove as a plaintiff that negligence occurred, there is no need for the defendant to defend this claim. Defenses to negligence occur in different types, from different types of defenses. Defenses that are based in common law, defenses that are based on contract, or defenses that are based on statutes, again, legislature passed law. So if the plaintiff actually proves their initial case that the four elements of negligence exist, then the burden, the legal burden here, the burden of proof, shifts from the plaintiff to make their prima facie case to the defendant to refute it. So we'll go through some of these defenses. Defenses based on common law, the first is called primary assumption of risk. So primary assumption of risk is where the plaintiff themselves cannot sue because they knew what they were getting themselves into. So the elements here are that the risk is an inherent aspect of the sport. So you can't separate the danger from playing the sport, such as going skiing, the risk of falling from going skiing, or the risk of getting injured in playing a contact sport, or the risk of potentially tripping over your feet while running. The participant must voluntarily consent to be exposed to the risk. So did they somehow voluntarily manifest a consent to the risk, and that they must also understand and appreciate the inherent risks. So they need to understand what they're getting themselves into. So with primary assumption of risk, the real question is whether the injury that caused the event was known by the plaintiff, or at least foreseeable when they actually went to do the activity. So courts here would use an objective standard. So again, more like a reasonable, prudent person from an objective point of view. So if you're playing hockey right here and you block a shot and you're not wearing shin pads and you break your shin and you try to sue for that injury, then the potential defense here would be primary assumption of risk, so long as you understood and appreciated the risk, your participation in the game was voluntary, and it was a risk that was inherent in the game. So can you separate the risk of being hit by a puck in the shin and still play hockey? Probably not. So that's inherent risk of the game. Next. So there are different ways to show primary assumption of risk here. The first is express assumption of the risk. And this would be actually getting the participant to set forth in words that he or she assumes the inherent risks of the activity. And here, this is where waivers come into play. And we've seen waivers, pretty much all of us have, at some point in our life. And it's just a legal document that is sort of a contract that says, in exchange for playing the right to participate in the activity, you waive the right to sue. Again, that's a contract because both sides are giving something up and both sides are receiving something. You are able to participate in the game, but you give up your right to sue. The other side gives up their right to have someone else participate, but gets potential immunity from liability. So examples here would be a verbal statement assuming the risk, could be a verbal contract, or a written statement, which would be more powerful because it's a written document that has been reduced. It's the written agreement that shows what both sides are getting, what both sides are giving up. Now, it could also be something where you verbally just say, hey, I promise not to sue you, but that's not going to be as powerful as a written executed contract. We can also have implied primary assumption of risk, which is, again, an objective determination by the fact finder, by the court, but they look, instead of it's verbally, we look at the conduct or actions of the person, that they voluntarily, that they, by their actions, assume the risks that are inherent or unknown. So again, you assume the risk that you may fall while snow skiing. You assume the risk that you might pull a muscle by running outside. So just by taking part in the activity, you potentially could assume the risk implicitly. Okay, now we move from primary assumption of the risk to secondary assumption of the risk, and that was called contributory negligence. So this is a situation where the injured party encountered a known or obvious risk, and they still chose to move forward in engaging with that risk. So this is more subjective. You look at whether or not they understood that they encountered this, and that they still move forward. So the participant voluntarily participates when there's a substantial risk that he or she will act in a negligent manner, and that although the provider has already been negligent, the participant chooses to go ahead and take part anyway. So the participant fails to follow the rules or heed the warnings related to the activity. So these are three potential situations. The participant chooses to participate even though there's a substantial risk that the defendant will act in a negligent manner. They just say, it's in a sense, it's okay, I'll go, I'll deal with it. The provider has already been negligent, and the participant takes part anyways, and also the participant fails to follow their own rules. So let's say that the individual chooses to go swimming after hours at a pool in an apartment complex, even though the pool is closed. But by engaging and by failing to follow the rules of that facility, they've engaged in a secondary assumption of the risk, and therefore very well might not be able to sue that development. So now those were based on common law, and that's, again, judge-made law. Now we've got defenses based on contracts. So that waiver, again, is a written agreement between the parties where one side gets something and the other side gets something, but both sides relinquish their right to sue. We've got examples in all 50 states of waivers being used. In at least 45 states, a well-written waiver is a good defense to a negligence claim. It will protect liability from ordinary negligence. But the question then becomes, what about gross negligence? Is that something where a waiver will not protect the party that's the contract? We've got another example, an informed consent agreement, which is just a written contract agreement that's used to protect someone giving a service to the other party. And it just says that the user or person who's signing has been informed of the risks of engaging in that activity, and by signing it, that they agree to assume the risks. So it's just a written out understanding. We also have contracts such as the assumption of risk agreement, which just has language in here that says that the signer explicitly asserts that he or she knows the nature of the activity and understands its demands, and appreciates the types of injuries that may occur as a result of participating. Again, it's just a way to establish that the other side understands the risks and they appreciate the risks of that activity, and there, because of that, there's a potential defense to negligence that the other signing party can fall back on. So we also have an example of defenses based on an indemnification agreement, and an indemnification agreements is a legal document that says the party that's signing off on that contract agrees to take on the legal liability that the other side might incur as a result of this activity. So with taking on the legal liability, that means that the other side will reimburse a party that's being sued for some sort of act that the other side participated in, and that's just a way to take the financial burden of the lawsuit and put it on another party. So some drafting tips for anyone that's actually going to be in sport management or in any business where waivers are going to be commonplace. Make sure that the waiver, the name of the waiver is descriptive. You don't want to be ambiguous. The print should be easy to see, so at least 8 to 10 point font. Avoid legalese. You want to make sure that the purpose and what's in that waiver is easy to understand. It should be no more than really one page. The word negligence should be used so that people understand that that's the topic of this waiver, and everything in that document should be honest, and that is really some of the high points here. You can look at a couple of other of these. I provided an example of a waiver on Blackboard that I do like regarding the Tough Mudder, and I like it because it's very easy to read, clear, and unambiguous. Here's some more general drafting tips that you can take a look at if you're so inclined. And then the final example, so we did common law, we did contract law, and now we're doing statutory. And again, these are laws that are passed by the legislature. We've got comparative fault and then immunity. So with comparative fault, that is a defense where even if a defendant is liable for negligence, the amount of the recovery is reduced based on how much the plaintiff is at fault. So if the plaintiff is at fault for an accident by 50% and he gets a $100,000 judgment, then that judgment will also be reduced by 50% and he'll only get $50,000 under pure comparative. Conceivably, under pure comparative, the plaintiff, if they're 99% liable and they sue and get a $100,000 recovery, they can still get $1,000, even though they were vastly the reason for whatever negligence occurred. Now, whether or not the comparative or modified comparative fault govern in negligence is based on from state to state. So it's a state-controlled phenomenon, so each state might differ. But modified comparative fault says that if a plaintiff is over 51% at fault, then he or she is barred from getting any money. So again, let's say that you get a $50,000 or $100,000 judgment and you're 51% liable as the plaintiff. That means you get nothing. You won't get $49,000. You will get nothing. So I want to thank you guys for staying with me on this chapter. I know it's a little bit thick, and I'm happy to field any questions that you might have. So thank you.